I'm Tommy Holderness. I'm with Legal Aid and the Housing Group, and Hannah.
Manager for the Charlotte office of Legal Aid of North Carolina, the supervising attorney with our pro bono programs.
And Justin Tucker, who is now head of the Housing Group, will be joining us as soon as he can weave the labyrinth.
He's an elevator T currently. I'll get us started and then they can join in. Okay, so just a little background on who Legal Aid is and who we serve. We are a statewide nonprofit law firm. That means we are free lawyers for all 100 counties of North Carolina. We provide services on issues that impact basic needs for North Carolinians, mainly shelter, fidelity, safety, so we do and economic opportunities. We do a lot of help with denial,
take you off mute.
Functions, driver's license, veterans benefits. A little bit about the clients you're helping. In North Carolina, the poverty rate is 13.6. This is based on the 2020 census data. There are just over 10, at that time, there were just over 10 million North Carolinians living in our state, and there were about 1.4 million in out of the poverty. Those rates are even higher for children, for 19.3, and working age women. Thus, it is not super surprising that most of our clients are female, 78%, and persons of color. Most of the clients we serve are Black, Hispanic, though we do, because we serve across North Carolina, and there are significant poverty risks. Eastern North Carolina and in the mountains, a good chunk of that is white as well. And then most of our clients are below 187% of the poverty line. Generally, that is a valuable number with our funding through the federal government. The exceptions for that, however, are for domestic violence. As you know, that financial abuse is a piece of domestic violence.
Less than 187% of the poverty line sound like a lot. Challenging what you're to operate your family on 87% of the government.
Yeah, I think it's less than about 55,000 for a family of 4. There is one legal aid attorney for every 8,000 eligible North Carolinians. We can't represent here at Legal Aid, and that's where you guys have been. We do have a number of rural offices that often serve more than one county. Here in Charlotte, we're grateful to be able to focus on Mecklenburg County. Most of our offices serve upwards of 3, 4, 5 counties. And last year we served over 55,000. Triage, that's why you're here. First, shout out to all of our housing triage champions. If you're here, stand up and clap. Woo! So these triage champions really make the wheel turn. We have monthly events that I'm going to go through, but they're the ones who are helping coordinate and recruit volunteers. And if you have questions, they are often seasoned in this housing work, and you can ask them. So we do monthly lawyer on the line events. These are available for lawyers and paralegals. You don't have to be barred in North Carolina. These are 2-hour, usually over lunchtime events where you provide telephone advice to tenants facing housing conditions and other issues with their landlords. Courthouse clinics. This is, in my opinion, where the fun happens. You go to court, you do intakes with tenants who are appearing that day for eviction cases on the spot. If they qualify for our services, you can go through, see if we can issue spot or legal defense represent. If so, if they don't qualify, you can still provide legal information to them as members of the public. We have a number of dates. I will be emailing tomorrow to everybody on this list with the dates and how to. And then we have full reps. So sometimes small claims courthouse clinic cases become full rep cases. Also, we do full reps for district court of appeal cases, or not just district court cases that are on appeal in small claims court. We do the full rep at the district court level just because there is a longer turnaround time. So it allows us to pair with pro bono attorneys. And now the main attraction.
All right, here we go. So I'm in court almost every day. So if you ever want to go and you get comfortable and you just want to come down there and help me out, I'd be glad to have you. It doesn't have to be an official thing. I'm just walking the halls, looking for the courtrooms, preferably the ones where the pro se landlords are. Because, and let me just start by saying, you being there, a lot of people have been through the process a lot, right? We get repeat clients, but we also get people who've been there first time. They think they're going to get locked out that day. They don't understand the process. They have a ton of questions, and just being there and talking to them and hearing their story and explaining to them that even if they lose, they're not going to get locked out that day. And the magistrates will all tell them, you got 10 days to get locked out, which is a lie or wrong, however you want to say it, because the reality is they have 10 days to appeal. If they don't appeal on the 10th day, the landlord can get the writ on the 11th day. It's not automatic. They have to ask for it. And then even if they ask for the writ on the 11th day, they don't get locked out to another 5 or 7 days. So even if the tenant just walks out without participating, they really have 2.5 weeks, not 10 days. And telling them that, you think, oh, what's the difference in a week? Well, a lot of times it's a big difference because people have nowhere to go and they're freaking out and they might be trying to move to their car a week earlier than they have to. So just being there and providing and listening to people and giving them some basic information, even if they don't qualify, is a huge service. But just once you start, you start.
I'm going to chime in really quick. Your first code is legal aid housing 1.
So a quick overview of the eviction process. First and foremost, the landlord must file a complaint of summary ejectment. Self-help is not allowed according to statute, and the summary ejectment only applies to tenants. So if you have a live-in roommate type of situation, it may not apply. A continuance can be granted, but not more than 5 days. It's going to be if it's contested by opposing counsel or opposing party. If it's not contested, then you can pretty much just go out as far as you want. We've had some cases, continued out 2 or 3 months, just to try to figure things out, even if we didn't get a settlement signed.
When sometimes the court dockets are so full that even if people don't consent, they'll push it out a month because there are no dates earlier.
Yeah. The answer is not permitted. Answer is permitted, but not required in small claims court cases. Now, that does change up if it's a criminal activity complaint and it's going to district court. If it's appealed from small claims to district court, then the answer is required. Landlords and magistrates encourage tenants to leave a lot of times without having a trial, which is unfortunate because, again, like Tommy just said, a lot of these tenants don't know, their rights, and they don't know the process and how this works. And so when they hear the magistrate says, oh, well, you can leave and try to work it out with your landlord in the next 10 days, they actually believe that. But a lot of times, depending on the landlord, that's not true. Because once the landlord gets that judgment, they have no inclination to work with you at that point.
And, our magistrates here, let me be clear, are very good. And especially compared to around the state, but even just in absolute terms, I think they're very good. But they get a little cynical or just kind of used to the process and geared up. And one thing I've heard them all say, they'll give a spiel to the tenants before they call their docket. And they'll say, if you want to have a trial to explain why you didn't pay your rent or why you breached your lease, you can. So they're coming in with this assumption that they haven't paid and that they breached, which, it's probably true most of the time. But I just don't like them saying that to people and assuming that that's the case. That's their default provision. So, and then this tenant, you have to be a tenant is true. That's a dangerous area though for our clients if they're not a tenant, because they win, because the judge will dismiss the case because they're not a tenant. But then if the judge writes on the judgment, they're not a tenant. So then the landlord can take that and call the cops and have them removed as a trespasser. So you got to be careful I mean, or just at least explain to people how, if they're not a tenant, that's going to be good for about 20 seconds. And then in about 2 hours, it's going to be really bad. And I've had magistrates before try to like dismiss a case because they're not a tenant. And I'm like, no, we think we are a tenant. We don't want you to write that down. They didn't file a deck action. So, I mean, sometimes our people aren't tenants, but that's something to be aware of. All right. Where are we going? Let's click away. All right. So in small claims court, first of all, if you're a litigator, small claims court is super easy. It's pretty fun. If you're not a litigator, you can do it. It's really not hard. The magistrates are so happy to have a lawyer there because what happens with the pro se people is they talk over each other, they talk about irrelevant stuff, and the tenants probably are more guilty of this than the landlords are. And so if they have a lawyer and they're representing the tenant who won't talk about all the crazy stuff or irrelevant stuff, but will just focus on the issues, the magistrates are glad to have you. And if you lose, you can appeal to district court, and it's a total do-over. So the only potential downside of losing is if your client can't pay rent bond, because if they can't pay rent bond, they get locked out during the appeal. But if they can pay rent bond, then they're there till their district court trial. And it's kind of like free discovery in a practice run. So don't feel like you've got to be Clarence Darrow to step in and have a trial. I've never heard of a opening argument in small claims court. Closings are made. The statute literally says that the rules of evidence generally apply, whatever that means. Trials aren't recorded, no court reporter. Occasionally they have an assistant there, but very rarely. So if you come in with cases and exhibits and they're multiple copies and they're highlighted, they love you. They typically rule the day of. They don't have to, but they typically do. If they rule the day of, even if the judgment doesn't go in portal that day, the 10-day appeal period starts the next day, which has been a little bit of a problem historically because the clerk wouldn't let tenants appeal until the judgment shows up in portal, which is kind of eaten into their 10-day period. But you just got to tell tenants, they can never let them appeal the same day, but they ought to be able to appeal the next day. I was going to say one more thing about that. I can't remember though. You got anything to say about that? Yeah. Yeah, so this drives me crazy. So I don't know if they'll all say it. Some of them might actually look at phones, but the general rule is electronic evidence is not considered. And Avery gives this whole, he's one of the magistrates, gives this whole spiel about how if you have evidence on your phone, I'll look at it, but then I have to keep your phone and put it in the file, which is such BS because they don't keep the paper. I mean, they return the paper, and so why couldn't he return the phone? But that's his excuse, and that's what he uses. But so you shouldn't rely on that. I think some of them will look at the phone, but Watson, I think, won't do it. Avery sure won't do it. I'm not sure if Mac will do it. I mean, if you're representing somebody and you're meeting them for the first time and they have things on their phone they need to use, that's a reason to ask for continuance. So you can print those things out and bring them in. And it's just better that way.
And same thing with videos. A lot of times tenants have videos of them trying to do something or interaction with the landlord. So same thing, and we've tried this. I've tried a couple of times bringing in several flash drives just to put it in the evidence. And the magistrate said, no, we won't take it. So to defeat that, you have to bring your laptop to turn around and show the landlord and the magistrate what this video is, because they would not accept the flash drive.
But you ought to bring the flash drive, because then if you get somebody like Avery, you're going to say, if you want to keep some in the file, here it is, but he won't keep it. But it's just ridiculous. All right, we'll get into how we try cases in a minute. That's what Justin was saying earlier about how this is part of the general statutes, is you have to use the courts. There's no self-help eviction. And even though, and like we had one lady we talked to today, and she was sued, and her landlord had called the police yesterday, and the police told her they were going to come back at 3:00 today and lock her out, even though she had a case today. And the landlord didn't show up today, so we got it dismissed. And then the police are still telling her, I don't care that it was a magistrate. Magistrates can't overrule the police department. We're coming to get you at 3. And so I was like, this is just so wrong. So I emailed him, left a message with Jessica Battle, who's the CMPD attorney. at the city attorney's office. And then I got another email saying, we're backing out of this. But if we hadn't been there to talk to this lady, I mean, she might have won in court today, but then if I hadn't emailed the lieutenant and called Jessica Battle, I mean, she might have gotten locked out anyway. I mean, it's just crazy. So just your presence can help a lot with situations that shouldn't happen. All right, so see how this says Article 3 or Article 7? Article 7 is all the criminal activity stuff. Article 3 is this.
Okay. And this is the 4226, which states that a demand for possession or surrender must be made in either of these three cases, or any of these three instances. When a tenant holds over, demand for possession must be made for surrender. When a tenant has breached the lease or done something that will make the lease end, the landlord must make a demand for surrender. And the last one, if it's a tenant of land for crops and abandons the premises. We don't really get into that at all. Our main focus is the 1 and 2.
And so it's a little bit confusing because up here it says who holds over and continues in possession. And so some people, I think, get confused about that and think this only applies to I'll call it a box 2 claim. You'll see paragraph 3 has 4 boxes, and that's the holdover claim. But it's pretty apparent that not only is it a holdover situation, but it's a breach of lease too. I mean, this is holdover and this is a breach of lease. And so in either a box 2 or a box 3, they've got to make this demand for possession. And I think the reason it says this up here, who holds over and continues in possession, is because down in box 3 even, it says his estate has ceased. And so if somebody breaches their lease, the landlord's supposed to terminate their either lease or terminate their right of possession. And sometimes we'll see people on a breach of lease case where they will check box 2 and 3 because it's a breach of lease, which is box 3, but then they terminate the lease, and so they check box 2 as well. I don't think that's quite right. I think box 2 was really written for your lease is up, I want you out, not your lease is up because you breached it. But just so you know, that's what you'll see. But there's another thing we'll get to in a minute, which is 42.3, which gives an implied forfeiture to a landlord if the tenant doesn't, if there's not a forfeiture clause in the lease, or if it's an oral lease, because otherwise, if you don't have a forfeiture clause and it's an oral lease, the tenant doesn't pay and the landlord can't do anything about it except just get a money judgment. And so the legislature said, well, we want to let landlords evict people, so we'll create an implied forfeiture. And if you tell somebody they owe you money and demand it and wait 10 days, then you can evict them. But I think, and this is something we're kind of arguing now and working on, that even if you get your implied forfeiture through 42.3, you still are suing under 42.26. Because 42.3 is in Article 1, and if you remember, the only way you can do it is Article 3 or Article 7. So all eviction cases have to come, that aren't criminal activity, have to come through here. So I think the 42.3 just puts you in the second paragraph there where they've done something, not paid. And I guess here's where it gets tricky, because it's not according to the stipulations of the lease, it's according to 42.3 that their estate is ceased. Maybe it doesn't. Maybe we should argue you can't evict them at all for freaking breaching 42.3, but that's the interplay between these. It's a little bit weird. And here's the thing. Here's the complaint. This looks so easy, and there's so many ways for landlords to screw up. I mean, and part of it I think is that it looks so easy. And I will say we win most of our cases because the landlord screws up. I mean, they just make a mistake. And so, remember back in your first law school days, civil procedure, where they're talking about the essential elements of a case? If you know the essential elements of a case, we win. I can't count how many cases I won without asking a question, without saying anything. The landlord does their whole spiel. The most important thing I say is, are you done? Because I want them to not say, oh, I wasn't finished yet. I was going to offer this. And I get them to say they're done. And then I move to dismiss because they've failed on an essential element of their case. And so, they put in their landlord, defendants if there are, if they got an attorney, it goes down here. They're supposed to say if it's oral or written, which can be helpful. They're supposed to say if it's conventional housing, public, or Section 8. I don't think these are essential elements. They're supposed to say the rate of rent, which if it's a subsidized tenant, is supposed to be the tenant share, not the full contract rate, which is a really important thing for rent bond, because the rent bond they're going to use it off this, and it should just be the tenant share. The tenant can't afford to pay the full rent. The date rent due, a lot of times you'll see landlords write the first. But if it's a breach of lease case and it's for non-payment of rent, they're supposed to put the month in. So like they should say, we're suing for May 1st as opposed to just the 1st. But you'll see that. And then this date lease ended comes into play if it's a box 2, the lease period ended on the above date. So that's why they got to put it in there. And that's when, if they hold over, that's the one that applies. So you'll hear people, us particularly, and even the magistrates talk about box 1, 2, 3, and 4. These are the boxes. And so box 1 is the 42.3 where there's no forfeiture clause and they make the demand for payment, wait 10 days. Box 2 is a straight holdover case. We're terminating your lease because we don't like you, or we just want to get somebody in there who'll pay us more money, or we want to sell it or whatever. Box 3 is a breach of lease. And if they check box 3, they're supposed to write in here what the breach was. 99% of the time it's non-payment of rent. And box 4 is criminal activity, and they're supposed to write in here what the criminal activity was. We will not give you a criminal activity case. They're very rare. They're more work. You got to understand what all but a lot of times if there's criminal activity, it's also a breach of the lease because it's the quiet enjoyment and stuff. So a lot of times they'll check box 3 and 4 with criminal activity cases. And then, yeah. It's pretty much drug use or things that like threaten the health, safety, and welfare. So if you got somebody who's using marijuana and chilling, you're okay. If they're out there, waving a gun, you're not okay. And then this paragraph is the one we hammer with the demand for possession because it says the plaintiff has demanded possession of the premises from the defendant who has refused to surrender it. So a lot of times when you can't represent somebody, you can ask them, and if you ask people, did you get a demand for possession? You might as well ask them if they, got a spanakopita or something. They're going to say no, but they don't know what you're asking, right? So you can't ask it that way. You have to say, did you get a letter? And don't say, did you get a notice from your landlord? No, I didn't get a notice. Oh, I got an email. Did you get a letter, notice, email, any piece of paper or electronic communication where they told you to get out, right? And then you say, just give me everything you got. But some people don't get them. Some landlords screw up. And if you circle this form and tell them that, they have to prove this, and if they don't, you might win, some of them can actually go do it by themselves. A lot of times they have something they want to say and it's not this, and they will not say it, so they lose. But some of them I've heard, like recently my guy, he told the magistrate all the 30 things he wanted to tell him and then said, oh yeah, and I didn't get a demand for possession pursuant to paragraph 4. And the magistrate said, you've been talking to somebody. And I just kind of raised my eyebrows in the back. So because the magistrates won't, it drives me crazy, they won't, most of the time, deny possession if the landlord doesn't prove their case unless the tenant says what the mistake is, which to me.
Also the time. Letter, say your lease is expired, you have 10. That was the only notice they sent. They filed suit at the end of the 2 days. And the magistrate said, the statute requires you to send a demand for possession after that 10 days because it was a holdover case. So the magistrate said you have to send a separate demand for possession after that 10 days is over because it's only after that 10 days is over that the tenant is technically holding up.
Which magistrate was that? Was it in 10, 30, 50, or 70? Okay, so 30 is magistrate, a black woman, and 50 is a white guy. Okay, so that's Magistrate Watson. We won that argument in front of all the ladies, Watson, Mack, and Williams. We lost it in front of Hands because in 4226 doesn't say when it has to be made. It just says after demand for possession. So she said, if they make it, after a breach or after telling them your lease is going to end and you're demanding that they get out at that point, that's good enough. I'm not sure what I think about that. I want it to be what you say, but the reality is, we see a lot of notice to pay or vacate. And most of the time the magistrates are going to say that's good enough, that, you're giving them this option, but you're telling them if they don't pay, you got to leave. But certainly make the argument that that demand has to come either after the lease is ended, if it's a holdover, or it has to come after the breach. I don't think you can make a demand for possession in a box 3 case before there's even been a breach, right? I mean, that'd be crazy because you just say it up front. And the other thing, I'm just going to rant. You will hear magistrates, even ours, ask tenants, ask landlords, does your lease waive notice? I've never heard a landlord say, no, it doesn't. We have to give notice. They all say, oh, it waives notice. They have no idea. They haven't read their leases any more than the tenants have. So they all say it waives notice. It's the wrong question. It's not a question of whether the lease waives notice. It's whether the lease requires notice in addition to what the statutes provide. Because if the statutes require, I mean, I'll call this a notice, a demand for possession, and the leases can't waive that. 42-25.8, I think, says any lease provision that's contrary to the statutes invalid. So the lease can't waive a notice that's required. It might not require notice in addition to the statute, but it can't waive it. And a lot of times you look in there and the landlord says, no, it doesn't require notice. And it does. And it's some crazy provision. And the landlords write all the leases, so you can hold them to it. I had one with First Key last week. And there was this provision that said any notice to vacate has to be given at least 60 days in advance. And I'm pretty sure it was written talking about the end of the initial term, but that isn't what it said. And so they had given a notice to vacate like after 10 days. And Fleet was like, nope, that doesn't work. So, read the lease, because no matter what anybody tells you, a lot of times there's some notice provision that and some of them will say it has to be in writing. Some of them will say it has to be signed. I mean, they're the ones that write these things. I mean, I don't feel bad about holding them to the fire because they're their leases. That's off rant. All right, so there we go. Sorry, so Justin, this is box 1.
All right, so box 1, fair to pay rent, like Tommy said, that's the one that requires that there is no forfeiture provision in the lease. And so 42.3 creates that forfeiture provision. And that says that the implied forfeiture if the tenant fails to pay all past due rent within 10 days after a demand for rent is given. And like Tommy said, though, what we've been making an argument is that after those 10 days have expired, you still need to now give a demand for possession, because this is just creating the forfeiture provision that your lease is missing. So keep that in mind. This is only used, like Tommy said, if there's not an automatic forfeiture provision or any kind of forfeiture provision in the lease. This requires, one, that the tenant is late, that the landlord make a clear demand for rent, a clear and unequivocal demand for rent. It doesn't necessarily, they don't have to necessarily say we demand that you vacate, but they have to demand the rent. And landlord must wait those 10 days for tenant to pay that amount before they then give that demand for possession. A lot of times we hit them on this because in that 10-day notice, the amount of rent they're demanding is inaccurate. They're demanding rent and other fees, which is not right. And so a lot of our magistrates, when we raise that argument, they would agree, like, yes, this is improper notice because you're asking for more than what you're really entitled to under the statute. The tenant can avoid potential judgment if it's a box 1 case up until judgment is entered, if they tender all the past due rent, including fees and court costs.
Not fees.
No, court costs, yes, including the court costs, which I think that was like
It's $126 if there's one defendant plus $30 for every additional defendant.
Yes, and again, the last point is the landlord must demand for possession after those 10 days have expired.
And they can make that tender anytime up to judgment in district court. So even if they lose in small claims and appeal, that window for tender still goes. But tendering is not asking the landlord, will you take it? Tendering is having cash or money order and going to them, either mailing it to them or going to them and saying, here you go, and being willing to let them take it out of your hands. And if they give it back, you've tendered. But we get a lot of clients who you'll say, did you pay? And they'll say they wouldn't take it. It's like, okay, that didn't answer my question, right? I asked you, did you pay? And when they say they wouldn't take it, you got a feeling that they didn't. But still, you got to keep asking the questions till you get the answer. And it's not, tendering is something harder than, but more and more people are doing it actually. But you've got to have evidence that he did it. You need the dates. Sometimes they'll send it out and they'll send it back, which is a beautiful thing when they write like, here's your money back. We didn't take it because a lot of times they won't take it because it's not the full amount, because they want the attorney's fees, they want the late fees. And if they just pay the rent and the court costs, it's not all those things, right? It doesn't include it doesn't probably have to include like pest control and trash and all these supplemental fees that show up as not as rent. It's just the base rent. And that's a huge thing. It's really fun to go into court and offer this stuff. And the statute says if you tender, even if they don't take it, the case is over. And so I actually like it better when they don't take it, because then the tenant keeps the money in their pocket and you have the same argument. There's always a risk. Well, I'll get to that later. I think this also 4233 also applies to a box 3 case, but I'm one of the few people that do. Yeah, Hannah.
Are the cases addresses the cases from where they're whatever.
Can you talk a little bit about tender when it's a month to month? Is that like that gets a little trickier, right? Because if there's a month to month, especially if it's not a written lease, but even if it was a written lease that has rolled over into a month to month,
Right.
and there's a failure to pay, you have to look to see if the landlord has terminated the lease or something like that. Because if month to month, the landlord does have the right to terminate by providing sufficient notice, and you can't prevent that termination of the lease by just tendering.
That's true. So tender is just a defense to a non-payment case. And so if the landlord has done kind of the two-step approach that Mark's saying, and they've sued for box 1, but they've also terminated the lease, then they can sue for box 2 and you won't beat it, as long as they did a proper box 2 termination. Because a box 2 termination on a month-to-month situation has to occur at the end of the period. If you're month-to-month, means the last day of the month. And whereas if you did a lease termination because of a breach, you don't pay me my money, I'm saying, and my lease gives me the option to terminate your lease. I'm like, okay, I'm terminating your lease tomorrow. And I'd have that right under my lease, but that ain't going to be a valid box 2 termination because I'm not terminated on September 30th. I mean, if the landlord's sophisticated enough to take a non-payment breach case and then terminate the lease at the end of the month, then they could file box 2 and 3 and your tender, or box 1 and 2, and your tender's not going to work. I hadn't met a landlord that clever yet, but maybe somebody will figure it out. God, there's so much more to say there, but I don't know if we say it here, maybe we say it somewhere else. If there is a forfeiture clause, then there's a case where you win if all they did is box 1. Depending on kind of the mood of the landlord, some days the mood of the magistrate, some days they'll let the landlords amend to go to box 3, which is a breach of lease, which is what they should have filed in the first place. And other times they'll be like, nope, you did it wrong, you lose, and I'm dismissing with prejudice. So, but that's always a winner if they check box 1 and they have a forfeiture clause. But I have one of those today, and I intentionally lost after talking to the client. Because if I had won today, then 1, they were month to month, and the landlord just could have terminated the lease at the end of October. 2, they could even if it's with prejudice in small claims court, the landlord can appeal and take a dismissal in district court, and it's without prejudice. And so it's like, this is going to be just a short-term win. Or I was afraid the magistrate might tell them they could get a continuance and then amend in court. And I think, and it's harder when you're in district court the day of trial for a landlord to ask to amend. And plus, it's going to be 2 or 3 months down the road. And so, and then the other thing I had to talk to my person about, can you pay rent bond? Are you sure? And they said they could. And so I was like, let's just go lose. And when we were doing trial, the magistrate was like, she knew the problem. I mean, she saw it. She's like, anything, counsel? And I was like, nope. I said, we consent to possession. And she's like, what? So I was like, we're good. And I've already started working on the counterclaims because there are a lot of debt collection violations too. So that's fun. All right, here we go. Holdover. This is box 2.
All right, holdover, box 2. That's the second box on the complaint that Tommy was mentioning earlier. And this comes into place with whether it's a month-to-month lease or a year lease. Well, no, it's a month-to-month lease. The landlord is...
Or a holdover at the end of the initial term.
Yeah.
Right.
And so the landlord must provide sufficient notice that they're terminating the lease at the end of that term. And we really get them on this a lot of times, especially if it's a hotel tenant, because it's hard for them to figure out a lot of times when the payments are due and when the term actually ends. Depending on the lease and the type of tenancy they have, it's going to really depend on the type of notice that must be given. If it's a month-to-month tenancy and the lease doesn't address it, then only 7 days notice is required. But a lot of leases, especially written leases, they will have a provision in there that says either 30 days, 60 days, or even 90-day notices must be given before the end of the term, before they can then, again, after they terminate, they must then give a demand for possession.
And that, so it's a longer of whatever's in the statute or whatever's in the lease, right? And then one thing that's not clear to me is if you have to give 30 days notice, if you put it in the mail on the 30th day, does that count? Or does that have to be received 30 days in advance, right? And sometimes the lease will say notice is effective when mailed, and if so, I think we're screwed. But other times, I've argued the whole purpose is to give them time to get out. And if they don't get it, until 27 days, that's not giving them the full 30 days. It also creates a situation where the landlord can't prove actual receipt. But most of the magistrates, if they can say they mailed it, they're going to give them that and assume. I think the general feeling is you presume that it was delivered 3 days later, kind of like the Rule 6 civil procedure thing of getting to add 3 days to service.
A neat trick here, though, is the third bullet point. If the claim fails, if landlord accepts rent after they terminate the lease or they sign a new lease, a lot of times I tell every last one of my clients, that's heading over the case, pay your rent, send your rent to the landlord. Because a lot of times, if the landlord keeps it, even if they don't cash it, the fact that they kept it, the judge would dismiss as rent being paid. Same thing if the landlord keeps it and what is it? If they keep it and they don't cash it, it would have.
And the new lease comes about a lot of times where a landlord will sign a new lease way in advance. And then before that new lease starts, the tenant will breach and they sue them for that breach. And then you just got to keep the case going long enough until the new lease starts. Because then the argument is you can't evict them for breaching the old lease because they're now living there pursuant to a new lease. And that works all the time. You just got to keep the case going long enough until they're there. The payment thing, though, I think to be technically correct, they have to make a payment for a period after. So in other words, if the landlord terminates the lease on August 31st, but the tenant still owes money for August, if the tenant comes in September and pays August, I don't think this is going to work because they're just paying what they owe. But if they pay for September, then and the landlord keeps it, then that's inconsistent with the landlord terminating the lease, so that works. So it's not so much the timing as what is it for. And if it's for any time after the lease is terminated, they're going to lose. And the hotel thing, good luck with that. Because really, when they're week to week, thank God we have calendars on our phones now, because I'm like, people have been there 3 years, and you're like, what day of the week was March 22nd, 2019? But you find out, and if it was a Tuesday and the landlord terminated the lease on the Monday, on any day other than the Monday, it doesn't work. It's got to be the day before the end of the period, right? I've had many landlords come in there and the tenant moves in on a Thursday and they terminate on a Thursday. It's like, that ain't the end of the period. What was it?
Resolved, and we saw more of them.
Court cases.
Had one yesterday. And for whatever reason, I'm not sure why, a lot of the hotel landlords will sue as a holdover as opposed to non-payment, which is good for us, but it really creates the problem for them of figuring out when the lease started, which actually shouldn't be that hard. Right? They ought to know when the person moved in. But those are all box one. I guess they're fearful. None of those are forfeiture clause cases. None of them are box three. They're all they would be box one. And then people could tender. So maybe they're trying to avoid that. I don't know.
Counting the dates can be where the termination letter was less than whatever the period was, 30 days or whatever it was. It's less than that period of time from when the complaint was filed. So I stood up in court and argued to the judge they didn't give adequate notice before they filed the suit. Landlord pulled out a copy of the delivery notification for that letter It had actually been delivered like 5 days before the letter was actually dated or something like that. So I thought I had a great argument on the timing, but he had, for some reason, like
Ford?
future dated his letter. The judge said, well, what really matters is how long the
Yeah, that's weird. And there's sometimes where a landlord will say something to a tenant, like you have this many days, even if they don't have, the other way, they'll give them more than they have to. And then if they don't honor that, the magistrates will all throw it out, even though they didn't have to. But they just don't like the fact that the tenant's being told something and then they're getting sued faster. And this seems really picky that a notice to terminate is not equal to a termination of lease, but there's a court of appeals case that says it. So they might not have to use the word termination, but they got to use something other than vacate. If a landlord tells them you have to leave by the end of the month, that is not a lease termination. Can you say I'm not renewing your lease? Probably. But it can't be just you have to leave. So I like to think of it as a lease termination is your lease is ending, I'm terminating, and then the demand for possession is get out. You have to leave. And think about this big picture for a minute too, because you have in a breach box case, box 3, you have a default, which is the non-payment or having an unauthorized occupant or whatever, right? And the lease will say most of the time, if it's a non-payment, then a default's a default. There's no right to cure or notice. In a non-financial breach, then we have to give you written notice about the problem and you have 5 days to cure or 10 days to cure. So, right, like get your boyfriend out, get the dog out, whatever. And then, so that's just the default. And then if you default, some leases say it's an automatic lease termination, and they can say that. Most of them say we may, at our option, terminate your lease. And if that's what it says, then they need to put on evidence that they actually have done that. Now, a lot of times the lease will say with or without notice to you. So that's a problem because they don't have to tell the tenant they terminated. But I think they still have to put on evidence in court that they did terminate the lease. And a lot of times they don't. They go in there and say, they didn't pay. Here's my lease. No notice is required. I win. I mean, that's just deficient on so many grounds, right? Because they're not putting on the demand for possession. They're not putting evidence that they terminated. And when you're making arguments, sometimes you just want to make one at a time because people will come back to you. And so you want to hold on to one so you can use it the next time and the next time. And I think our record is 6 about keeping somebody in over and over because we didn't educate the landlord about all their problems on the first round. All right, so this is box 3.
Box 3, violation of lease term. So the lease must permit landlord to terminate the lease upon tenant's breach. Most rental leases do that, but not all of them. And some of them also have automatic termination upon the breach of the lease. Like Tommy was saying, most non-payment cases are brought as a breach of lease. The breach must be described in box 3, in paragraph 3. In the box 3 case, it must be described in paragraph 4, is it?
It's in between paragraph 3 and paragraph 4.
Yeah, and normally the breach is going to be non-payment of rent. But if it's anything other than non-payment of rent, it must allege it in that box. There have been plenty of times where, the landlord will put, unauthorized occupant, but then come in and try to argue something else. And we would get the rest of the argument tossed out and just strictly focus on the unauthorized occupant. Before filing, again, the landlord must make a demand for possession, and that's regardless of the type of breach it is, whether it's non-payment or any other breach of the lease. But like Tommy was saying earlier, if it's anything other than non-payment, keep in mind of the potential cure provision because they have the time to cure, and a lot of times tenants do cure, or depending on what the breach is, it might not even be an opportunity to cure. Like I had one case recently where the landlord was suing for threatening the manager's staff, office staff. And they said, in the termination notice, don't come back to the office anymore. That was it. And so when they brought the eviction case for breach of lease based on, the harassment and the threatening of the office staff, I asked, had the tenant been back to the office? And they said, no, the tenant hasn't been back to the office. And I said, well, then she's cured according to your notice. And then the landlord tried to go into nothing else, and the judge said, no, I'm not. According to what your notice says and what you're bringing this case for, the tenant cured. You told him not to come back to the office. They didn't come back to the office.
It's like I said earlier, most people, I think, in the state would say you do not have a right to cure on a box 3 case. But if you get a case and your tenant client can pay all the past due rent and the court costs, come see me, find me, because I will argue that till I die. And I think I will make headway, especially with certain judges. So it's not, there's a Court of Appeals case, the one we use the other way, Charlotte Office Tower from the 80s, that says it doesn't apply. But there's a 2020 Supreme Court case which cites 4233 in the Box 3 case and says it's dicta probably, but it indicates that it does apply. And 4233 says in any case for non-payment of rent. Seems pretty clear, the language. Any case for non-payment of rent. It's not even the same section as 42.3. So if you get a tenant that has tendered, you find me. The other thing is when you're talking to your client, interviewing them, and you're trying to figure out what's going on, you're going to say, did you pay your rent? And they're going to say, what happened was, and they're going to tell you a bunch of other stuff, right? And that's a lot of clients want to tell the court why they didn't pay to convince them they're not a bad person. And there are a gazillion reasons people don't pay, other than they're just like, betting on sports. And so, but it doesn't matter, but it matters to them. So you have to try to balance this, listening to people and letting them say what they want to, while also moving them on to the important things about what you can use to win the case. And you probably should ask, why didn't you pay? Because if the reason is because my heat didn't work, or my roof's caving in, then that reason does matter, right? I mean, it might not be a total defense because the problem would have to be significant enough to get the rent down to zero, or would have had to have been occurring for a long period of time. But if they're withholding because of repairs, you need to talk to one of us. But if it's because they lost their job, because their mother died, whatever, you got to hear them out as a matter of empathy, but it's not going to help you win your case. We're not even going to go to criminal activity. There's just a lot of stuff there. We don't have any time. That's what I was just saying. The clients want to talk about other things than what matters. And that's one of the value that you bring, is what matters, and they don't. So they want to talk about why they can't pay. The other thing that's really important, and this is just a trial tip in general for anything you do, Rule 602 of the Rules of Evidence, North Carolina and federal, testimony must be based on personal knowledge. And people will say things all the time that they don't know. They'll just do it. So one of my favorite questions is, how do you know that? Because people, and if they say, I saw my landlord do something, or I paid this, great. But they will tell you things that it's not apparent how they know. And when you ask them how they know that, like, for example, they wouldn't take it. How do you know that? Did you offer? What did they say? And I just know they wouldn't take it, which means they don't know, right? But ask them that. It's very effective in cross-examination as well, because landlords will do the same thing. When you hear passive voice, this notice was sent. Boom. I mean, there it is. Like, that means they don't know, right? Because if they knew, if they sent it, 99% of the time, they'd say, I sent the notice. When they say this notice was sent, they're assuming it. So on cross-examination, you say, did you send the notice? And it was sent. But I'm not asking you if it was sent. I'm asking if you sent the notice, right? And most of them will admit, no, I didn't do it. It's corporate policy. Like, I don't care. It's corporate policy. You didn't bring the person who did it. And we win a ton of cases because they don't bring the witness that actually sends the notice. Now, if the tenant admits to getting it, you're screwed. But if the tenant says, I didn't get it, and they don't bring the right person, that's a freaking winner for you, time and time again. I was reading the book recently, and it was the witness, like, I know it was him, some rape case type deal. And the detective says, let's forget what you know. Tell me what you saw. And that's kind of the heart of the matter, right? I don't care what you know. I want to know what you heard and what you saw.
And landlords are starting to get a little hip to that argument, and the fact that we're doing that, because they're getting their attorneys now to send a notice, which I still don't think works, because the attorney can't testify that they sent the notice in their own case. But the magistrates are still letting it go through when they ask the landlord, did you contact our office to have us send this notice? And they're saying yes, and and going and so forth. And the judge allows it to come in.
Two of them do. One of them doesn't. If you're in 70, she won't let it fly. 30 and 50, they will. One attorney, local attorney, she's actually having her paralegal send out the notice, and she brings her paralegal. And Shantae's figured it out. But, good for her.
In that case with the lawyer that sent it to you, does the lawyer then say to the magistrate, yes, I was hired, the landlord says, I hired them to send out the notice, and then just the lawyer,
he just hands it
He
up.
just hands up the notice.
It's got a certificate of service on it, as if that's like some Willy Wonka gold sticker.
Yeah.
I mean, and It's like, who freaking cares? It's got a certificate of service on it. And he doesn't even sign it. His sister signs it. But Avery will take it, and so will Watson. So, yeah.
And even the timing of that, we've had cases recently where they would send that notice out a day or two before filing, where there's no way that the tenant would have received this notice to know, okay, I need to get out. And the magistrate still, because again, like,
So I've had that. I've won those. If
we-
they
I've
mail
won
it the day
some.
before, I guess you
Yeah.
never know.
yeah, Watson has said no. There's no timing requirement. It doesn't say that they have to receive it. They actually have to get it, but as long as they were sent out before they filed, it's good enough.
That's one more kind of trial pointer for small claims court. In district court, and where y'all probably practice, you have to officially move documents into evidence. In small claims court, they're moved into evidence by just handing them up. And so you don't actually have to make the motion. If it's your exhibit, you just hand it to the magistrate, and if they get it and nobody is objecting, they'll take it. So if the other side is handing up a notice, you need to object right then if you don't like it and say, no, I don't think this is good. They haven't established personal knowledge that it was delivered, so it's irrelevant yet. And that's the time. Don't wait for a motion to admit. It ain't gonna come. There's 602. It's so great. 803. You'll also hear time and time again, oh, it's a business record, right? They got some notice that somebody in Arizona sent, and they stick it in their file and they claim it's a business record. That's a hearsay exception. You're not talking about the truth of the matter asserted in a notice. The question is, was the notice delivered, right? Now, this can get a little dicey if the notice says, if somebody signs it and says, I mailed this on such and such a date, because then it is the truth of the matter asserted because delivery is part of the notice. But most of the time, the notice doesn't have that. It's just, Dear Jane, you owe this much money, pay by this days, or you got to get out within 10 days. And in that case, there's nothing, you're not objecting because that's hearsay. You're objecting because they don't have a witness who can testify it's delivered. And because your objection isn't hearsay, the business record exception shouldn't do anything for you. That doesn't get you by that's not a bypass for personal knowledge. It's just a bypass if the objection is hearsay. That's the tip for all your life. We don't talk about that. Again, how do you know that? It's a way to go. All right. Boy, we got to do this fast, but go ahead.
No, go ahead. We got like 5 minutes, I think.
A retaliatory eviction, we hardly ever use that anymore. There was a case that came out a while back that just killed us on that. So we rarely get to use that, even though you'll hear clients say, oh, they're harassing me, they're whatever. This just doesn't work much anymore. DV victims have a host of rights, and they can terminate the lease early. They can't be evicted if, like, for disturbing the community, if they were being attacked, if that was the problem. They still got to pay. But where we get the most out of DV related things is this VAWA notice, Violence Against Women's Act, and any federally subsidized property, which includes public housing, Section 8, or LIHTC. If every lease termination notice has to include the certificate of the notice of rights and certificate of compliance. There's something like 2 documents they have to get, and they have to give it to them every time. And if they don't give it to them, the landlord loses. And we went on that all the time, and the landlord said, oh, well, I gave it to them when we recertified. I gave it to them when, it's like, great, that was good, you were supposed to. But you also have to give it to them now. And if they don't give that and it's subsidized property, they lose. Reasonable accommodation, that's a whole nother topic that I'll not get into. With disability, but they've got to have made a request. You can make a reasonable accommodation request even during a lawsuit. You don't have to have done it beforehand. So that can be effective. And then a lot of times the amount claimed is just wrong, especially on the box 1 cases. And then sometimes people will pay, especially these big corporate landlords that are out of state where they're mailing payments in. Occasionally you get a tenant that comes in and they've got all their money orders. Like, here, I've got it. So that can be a winner. And then the demand for possession is a winner all the time. Yeah.
Retaliatory, you can still make an argument that a landlord can't evict a tenant for asking for an inspection from the city.
Yeah.
So
So
if the tenant calls up the city and says, I have roaches or I have a broken toilet or something like that, and the city comes out, the landlord gets a report from the city saying you need to fix all this stuff. That's not a basis. And then there's a eviction shortly after that, you can still make a retaliatory eviction.
Yeah, but if they're now month to month and the landlord terminates the lease, I'm not sure it's going to work in that case because of this case that says it's just bad. And even if you do have even prior to that case, when you had a retaliatory eviction possibility, there was always a way to get out of it if you actually owed money. It never worked that. We just don't get to use it much. You got to do these forms. You don't have to do all these forms. You don't have to pay rent bond, but if you don't pay rent bond, the landlord can get the writ. It's not automatic. Remind them of that. And Loebsack and Brownlee, they don't do this for their clients anymore. And their clients won't see it. So a lot of times people don't pay rent bond and they stay in there for months, which is great, but they're risking it because they could get locked out at any time. And it's a race. Once you get through the due date, you can pay late unless the writ's been requested. And at that point, you're toast. Yeah, Hannah.
So this slide is probably one of the most defense stuff. Right. Everybody has the right to appeal. Even if a tenant doesn't have a legal defense, they have a way to prolong the proceedings so that they can stay in their home a little bit longer and figure things out, maybe get the night together in 4 to 6 weeks that they can't get together in 7 days.
And it's roughly taken 2 months now, like 2 to 3 months. It's hard to know exactly when it's going to be set. There's a new law that was just passed. Governor vetoed it, got overridden, and it's got some weird provision. Well, it used to be that the law said landlords can get their attorney's fees. It didn't even make them win. It just said they can get their attorney's fees. That's a fee they can recover, 15% of the amount due or 15% of the monthly rent if it's a non-financial breach. They changed it to now landlord at least has to win, hallelujah. But if there's an appeal that's solely for the purpose of delay, then they're entitled to recover all their attorney's fees. I don't know what the judges are going to do with that, how they're going to make that determination. It also says if it's bad faith or something else, but that's just brand new and we haven't seen how that's going to play out. I wouldn't let that discourage any of my clients from appealing, especially if they have nowhere to go. That's the other big thing. When you're interviewing people, I want to work out a deal. I can pay by next week. I can get out by the end of the month. And it goes back to, you got to ask them how. How do you know that? How do you know you're going to be able to pay? And a lot of it, people will talk to you in terms of aspirational goals. But the landlords typically want the settlement agreement to say, if they don't get out, if they don't pay, then they lose. It's a judgment without trial, and they give up their right to appeal. So it's really bad. And I had one last week, and they was like, I can pay today. It's like, oh, great. So I go to talk to the landlord and say, you can pay today. Like, okay. And then the landlord comes back, what time? I said, well, how about Friday? It's like, well, so do you have the money or not? She's like, well, no. It's like, how are you going to get it? I'm going to get it from my IRA. And you can get it from your IRA in 2 days? It's like, well, maybe not. And so, right, like somebody tells you something and it sounds like they can do it, but you have to ask the next questions. How are you going to do that? And if they say, I'm going to move at the end of the month, I mean, you got to be a little nosy. Where are you going to go? How do you know you? And I've been applying. That's worthless, right? I'm going to go live with my mother. Have you asked her? Has she said yes? I mean, really, these seem like crazy questions, but otherwise people are going to agree to things they cannot do, and they're going to give up their appeal right, and then they're going to lose, and it's not a good feeling. But we can help you with these 3 forms. They're pretty easy to fill out. And one of them lets them avoid the $150 filing fee, and they don't have to pay the back rent to stop the writ. They still owe the back money. They just don't have to pay it to stop the writ during the appeal. And that's what the bond's all about. The petition to sue as indigent is the waiver, as well as the not having to pay that other money, and then the notice of appeal. The only form that has to get mailed to the landlord's notice of appeal. The other 2 just get filed with the clerk.
Verified rent.
And it's going to be that amount in paragraph 2 of the complaint. So like a lot of tenants, they might owe $1,400 for rent, but then $25 for valet trash and $4 for pest control and $75 for internet. And the rent bond number will just be the number in the complaint, the base rent number, which is good. Yeah, you can do discovery on appeal. You can, if you do discovery and it doesn't get answered, you can move to continue the trial the first time, and it says shall be granted, and so it automatically gets rolled over, so you can buy time that way. I recommend Occasionally, you'll see a tenant serve discovery 2 days before trial. That's technically allowed, but it doesn't go over well. If you're a lawyer, I would not want to be going into court saying I just served discovery 2 days ago unless I just got retained 3 days ago. So if you've had the case the whole time, I think you would need to serve discovery within a week or so of doing the appeal. Don't wait. And then, another thing about, especially if y'all are civil practitioners, when you serve discovery, put it on your calendar when it's due, because if you don't get the answer, you got to follow up and you got to make the motion to compel. Because if you show up at district court trial and say, oh, I served discovery 3 months ago and they never answered, and you hadn't moved to compel, the judge is going to say, well, it must not have been very important, or because you hadn't moved to compel. So you got to take those steps. And in Mecklenburg, it takes like 5 weeks to get a motions hearing. So it can take a while. So you've got to be on it and get the process moving, or you'll never get your order to compel before your trial date. We're doing calendar call in person now, 6330, but trials are still remote unless you ask in advance for it to be in person. Go in calendar call, they give you a time. Most of them are 2-week sessions. They give you a time and date within the next 2 weeks. Tuesdays are motions days, so it's Wednesday to Friday or the following week. They're going to, just FYI, the people, the pro se tenants, they're putting them for 15-minute trials. That's how fast they are. If we show up, they're typically at least an hour. If we have counterclaims, they're 2 or 3, but they just run through them like clockwork. And they load sack and Bradleys in the hall. They try to work out deals where people leave. If anyone wants to go to I kind of do a calendar call clinic where I go on Mondays and I go sit outside 6330 and I talk to people and I look for some of my favorite landlords. And so if anybody wants to go do that, and then I'll tell people, you also, because they're remote still, one advantage is you have to trade exhibits the day before. And so I'll tell people, look, I'm not trying to represent you because I don't know what's going on. You're telling me stuff. But if you send me the exhibits the day before, make sure you give your email information to your landlord attorney. When you get the exhibits the day before, forward them to me, I'll look at them. If I see a problem, I'll represent you. I'll do it today. But if they give me the documents and it looks right, I'm not just going to sit there and get crushed. Even though sometimes you might want to, because they still might not have the right witness. And then remote trials, if you hadn't done one, it does take some practice. You got to share your screen. It's harder. It's better if your client's with you. If you're in one place and your client's in another, that's tough. So if you hadn't done it, come to us. There can be, particularly if your client got a document, right, and you don't want them to be asked, did you get it? Because then they have to say yes. Know that Judge Fleet, who is generally very good for us, she wants your client there. And if they're not there, even though they don't have to be there, and even though they haven't been subpoenaed, it is not going to go well. So with her, at least, you better bring them. But yeah, there are plenty of times in small claims court, especially, and sometimes in district court, it's sending a bad image of your client doesn't care enough to show up. So oftentimes I'll preface it with well, they had work, or they had, whatever thing they have to do otherwise. But yeah, it doesn't look good. But if they're not going to have anything to say that's going to help you and they would hurt you, then yeah, I tell people not to come. Yeah. 5 minutes. Hannah's telling us we got 5 minutes. Fair enough. What's that?
Repairs.
Yeah. Okay. Sure. Repairs. The Ritz. Yeah. So habitability, people tell you, I got a problem. And great. The worse the problem is, the better it is for you as a lawyer, the worse it is for them. But when you talk to them about repairs, the critical thing is what's the biggest, start with the biggest 3, right? And they start telling you that they got ants, that probably ain't gonna do much for you. Or if their dishwasher's broken and they don't cook, that ain't gonna do much for you. If they got sewage issues, that's the Willy Wonka ticket. If you have pictures of sewage backup, that is always a freaking monster winner, especially if the lady's 8 months pregnant, which was nice recently. So the key with the repair stuff is, one, if they hadn't called code, they should, 311, because the city will come out. That's a neutral party documenting all the things. And sometimes they'll find things that your client doesn't even know about. But they have to establish when the problem started and that they told the landlord about it. Most of the time, it doesn't have to be in writing, but the judge ain't going to believe them unless it is. So you need something in writing. Most of the time, it's going to be an email or a text with a date on it when they say, my AC didn't work. And then the landlord has a reasonable time to fix it. And if they don't, they get some discount. The question I like to ask people is, how did this impact you, right? Because think about it this way. If you got 4 bathrooms and one of them's down and you're 3 people in the house, it doesn't matter much, right? So the fact that a bathroom's down because it doesn't work, plumbing's terrible, that sounds bad, but again, with 4 bathrooms, it's not that big a deal. If you have 1 bathroom, it's a huge deal, right? We had to go shower and go to the bathroom at the restaurant down the street. So again, nothing's absolute. Most things require a follow-up. How did this impact you? And then the judge is just going to pick a number out of the air for what kind of discount the person should get. And if it's just been going on for a month, it ain't going to be much. If it's been going on for years, it's going to be more. And if the client's been paying, they can get money back. And it can be trebled if the landlord knew about the problem. Key is if they knew about the problem. There are 13 things in the city code where it says the landlord shall not collect rent if these things exist. We argue that that means the fair rental value in the actual condition is 0. Judge Levine didn't agree with me. We got that case on appeal right now. And the problem is if she did agree with me, I would have won $225,000. And I think that was a little much. So she gave me a 15% discount instead of taking it down to 0. So we'll see. But those you generally, pictures are very helpful. Video can be really helpful. But the biggest thing is that notice and writing of the problem, because landlords aren't expected to fix something they don't know about. There's so much.
And follow-up communications. Just don't send one complaint if it's ongoing. Keep following up, keep complaining, document. That's what we need, evidence and documents.
And if it's a housing code violation, you have to introduce the housing code into evidence. You can't just talk about it. You actually have to print out the code and hand it up. Clients will tell you they got mold problems all the time. We're not mold experts. We're not personal injury lawyers. I tell people, if you're sick from mold, you need a personal injury lawyer because you have to have a doctor who can testify that they test that mold and they can say that mold made you sick. There's mold all around the world and everywhere. And so to show personal injury, that is beyond our expertise. I can say if you got mold and it's grotesque and it's all in your bathroom or your kitchen, then you should get a discount for that. But that is not the same as being sick or mental anguish or whatever. So you got to send them somewhere else. That's the whole thing I was talking about with habitability. If they know about the problem and still take the rent, you get it back plus ×3, which is great. I don't even think that's right. That's way too hard. Debt collection, we make a lot of money. We make a lot of money for our clients on debt collection claims. The minimum penalty for a debt collection claim is $500. The most is $4,000. And a lot of times those charges will be recurring monthly. And so it can really build up over time. Tenants frequently, they don't even know they have this claim. It comes up most often with late fees. Late fees are charged too soon or too much. But it also can come up with any other kind of fee that's on a monthly basis that's not allowed for in the lease. So this can really be the golden ticket to get people out of debt. And one time I had a magistrate find that the landlord owed my client $8,000 and my client owed $5,000 and she still evicted them. But every other time, if the landlord owes the tenant more than the tenant owes the landlord, the judge or magistrate has offset it and said no eviction because there's nothing the tenant owes because the tenant is owed money. But they don't have to do that. It's Rule 13C of the Rules of Civil Procedure. But that was just one time. That's the judge that's not in there anymore, so I think we're safe. But yeah, debt collection is a whole other thing. If you have a monster debt collection claim, come talk to me. A lot of landlords will increase rent without permission. Some leases say they can when it goes month to month. Most don't. Most say it rolls over on the same terms and conditions. So if the landlord just increases the rent because they think they can and the tenant doesn't agree, those are going to be debt collection violations for the increased rent and probably for the late fees because they're now charging 5% of the higher amount instead of 5%. That's actually what it was today that I had. 5% of the higher amount. This is that thing I was talking about earlier. I had this great argument about Rule 6 that 4246 used to say you can charge a late fee if it's 5 days or more late. Didn't say whether it was calendar or business. And I was arguing Rule 6 of Civil Procedure says if it's fewer than 7 days, it's business days. And the legislature just amended it to say, no, it's calendar days. And that's a clarifying amendment, not a substantive one. So you got nothing. So basically that argument's been taken away, which is a bummer. All right, my scenarios.
Okay. That was a lot of information, and thank you guys for sticking with us on that. I promise you, it's not scary to do this work. We hold your hand the entire way with the courthouse clinics. We will co-counsel with you. We will mentor you. We will be by your side until you're ready to hop out of the nest by yourself. And we're actually going to go through a mock scenario for our lawyer on the line. And then if we have time, a mock scenario for a courthouse clinic. So, Paul, Todd, Floor. Yeah, come up front. That's where the cameras are.
Oh, whatever's easy. Okay. Sure.
If you guys can identify yourself as the client. Volunteer attorney.
There we go.
All right, so this is for lawyer on the line. I'm going to pretend I'm a lawyer dressed up for it here today. So I called the tenant here. Hi, I'm calling for Mr. John Renter. My name's Paul Osowski. I'm a volunteer attorney with Legal Aid of North Carolina. I'm calling to talk with you about the housing issues you have with your landlord.
Well, thank you for calling. My landlord is the absolute worst. He never fixes anything. I haven't had air conditioning all summer. I've had to buy big box fans for every room in the house, and it's absolutely horrible. What can I do to make them make the repairs? Can I just break my lease and move out? I just don't know what else to do.
I'm sorry to hear what you've been going through. It sounds incredibly frustrating. I'm going to back you up and ask some questions so that I can give you legal advice on your situation.
Okay.
When did you move in?
About 2 years ago, I signed a new 1-year lease in January 2024. It goes through December this year, but I don't think I want to stay that long.
What repair issues do you have, and when did they start?
Well, I've had issues since about 3 months after moving in, but they've usually fixed things. My dishwasher didn't work for about 4 months last year. And then I noticed some mold in my bathroom in January this year. They've come out and painted over it, but that's it. And then my HVAC went out March 13th this spring, meaning I had no air conditioner all summer. They've sent a maintenance man out 3 or 4 times, but it'll work for a day and then stop working again. The last guy said that the unit is shot and a new unit is needed, but the landlord is too cheap to replace it. So it just keeps breaking.
How did you report these issues to the landlord?
I called the property management office and I told them every time the AC went out again.
Did you put anything in writing, either through a portal with the landlord or an email or text message to him?
Did I need to?
No, but it helps if you have a paper trail. This way, if the landlord doesn't make the repairs, you have documents in case you have to go to court regarding the repairs. Did you call code enforcement?
No. What is code enforcement?
Code enforcement is a local government agency responsible for making sure homeowners keep their properties up to the minimum housing codes for the area. Their inspectors will come out free of charge and will note any violations of the housing code. This puts the landlord on the clock for making the repairs. If the landlord doesn't make the repairs by the government's deadline, the government can start fining the landlord for its violations. This threat of fines often lights a fire under the landlords to get the repairs made. I'd recommend that you contact code enforcement by calling 311.
Okay, well, I'll do that today. Does it matter that I haven't paid my September rent yet? I don't have any eviction papers.
That does make a difference. While the landlord can't retaliate and file an eviction case based on you requesting repairs or a code enforcement inspection, they can evict you based on non-payment of rent. You likely have rent abatement claims, essentially money back for when the repairs haven't been made. However, you should continue to pay rent to avoid the risk of an eviction filing against you. It's safer to get your balance current and then report to code enforcement. If you report first and landlord files an eviction case, you could file counterclaims based on the repairs. Then a judge would decide who owes who more. You can do it this way. It's just riskier.
Okay, but what do I do once I get caught up on the rent?
First, call code enforcement and gather all your evidence. Take photos of the repair issues. Make a timeline of when you called the landlord and reported which issues. Collect all the receipts for items you've spent money on, like the box fans, since the landlord hasn't made repairs. These are what are called consequential damages. You can ask for reimbursement of them too. Then you can file a case in small claims court for money owed. I can send you a guide on how to fill out all this paperwork, and then you'd get a hearing where you'd present all this evidence to a judge and ask them to award you a money judgment against the landlord.
And you're going to represent me in that, right?
No, unfortunately, I cannot represent you, but I can send you information on how you can represent yourself. Do you have any other questions right now that I can help answer?
Yeah, what if I just want to move out instead?
Depending on what's in your lease, there may be penalties for you breaking the lease before its end date in December. I'm happy to take a look at your lease if you want to send it over right now. Often leases require that tenants are responsible for the rent through the end of the lease, even if they break it early, unless the landlord is able to relet the unit. If you really want out of the lease, you could see if the landlord would sign something allowing you out of the lease without penalty. If not, you could see if landlord would let you out in exchange for you waiving your repair money, waiving your repair money owed claims. They may or may not. But if you do agree to something, you should get it in writing and signed. Any other questions?
Not right now. This is a lot to think about, though.
Okay. I'll send you a closing letter going back through this advice and include some informational guides so you can decide how you want to move forward. Remember, if you do get eviction papers, please call legal aid back immediately.
Here we go. Yep.
Right.
But does it form and what takeaways?
Yeah, this is pretty close to it. It's a lot of fact finding with the tenant. The other thing too is, sometimes the tenants want to tell you all this other stuff, like Tommy was saying. It's sort of like listen to them for a couple seconds, then like, okay, I hear what you're saying, but here are some of the legal issues that we need to find out, some factual stuff and legal issues that we need to get you back on track with.
Yeah, and I would say that for those of you like me who are not litigators and are maybe just getting started, the other thing is this wouldn't happen in just one telephone call. Probably what would happen is you would call and the tenant would give you all the details, and then you'd go back into the conference room and talk to somebody like Hannah or Justin or Tommy, and they would kind of help you formulate, and you'd call them back. And then maybe you still didn't get part of it right, so you go back in the conference room. But again, you can get as much support as you need to. You're not expected to be able to come up with the answers Paul did off the top of your head.
Right. And the other thing is you're real well prepared by legal aid. They've got a folder that has all sorts of information about this tenant, sort of some background information. So you kind of have an idea of what you're getting into before you make the phone call. And then we do it in pairs so that one person is speaking with that person while the other is kind of taking notes and filling out information on a computer.
Yeah, and I feel really good when you're done. The materials that Legal Aid has for pro se representation are excellent. And the lawyer on the line, experts that are there with you will help you make sure that, when you say, I'm going to send you this or I'm going to send you that, that they get some really good instructions on how to file their case, what to be concerned about. And then, of course, you're going to do a follow-up letter that's going to memorialize all of that. So, if the person is able to read your letter, they should have some good direction on what to do next. And they're so much better off than if they tried to do it without talking to you first.
Absolutely. Yeah. And I've found just not only in Lawyer on the Line, but in just some of the other representation matters we've had, one of the first questions they always want to ask you is, do I need to keep paying my rent? Can I stop paying rent? And of course, the answer to that is almost always no. You need to keep paying your rent here. And that was, obviously one of the issues that came up here. And then the other big thing is if you've got habitability issues, have them contact code enforcement, because most of the time they have not contacted code enforcement yet.
Exactly.
So these are clients that otherwise be or by.
These are clients who have issues that are upstream prior to the eviction filings. And so being able to catch them at that point and tell them, yes, do keep paying your rent, or start documenting now about your repair issues, because if it gets to that eviction immediate urgent juncture, this is going to save your butt. So
Do we have something in place so that it's a faster situation?
yes. So if you get a case on Lawyer on the Line and the client gets on there and says, oh, it's the middle of December, my heat is not working. So that is an urgent situation that we qualify as self-help. We then refer it to our local office. Similarly, if they get on the line, they live within developing situations and they say, oh, this morning eviction papers came. We then refer it to our local office for follow-up. You guys are not expected to handle that. You have only signed up for the 2-hour event. And we do host these events monthly. They're hosted around the Charlotte area, and all of the events are open to all Charlotte attorneys and paralegals. While they are hosted at the great firms, the banks, et cetera, they are open to everybody.
Yeah, and
So
actually,
it's a great way to network too.
what's great about this particular volunteer opportunity is you do not need to be a licensed attorney. You're gonna, all of the advice that you give is going to be vetted through the legal aid attorneys that are on staff, where you're going to get paired with an attorney. So this is a great one to get. If you're comfortable enough to talk to the client on the phone and write the letter, you can do this clinic.
And the letter comes from legal aid. It's on their
that's right.
letterhead. So you're not writing it from as yourself from the law firm. It's
No, that's right. And we always have stuff set up so you don't have to call from your own phone.
Yep.
So you really are not going to have any tail to this assignment unless you want it.
We had a question?
That's my question. And one of these
Mhm.
great. Biggest question I had at first lawyer on the line clinic, how are you guys ensuring safety
Mhm.
of, you were on the phone with guys for a very long time,
Mhm.
filled out what we needed to that was gonna go into the letter, but he was sort of like, well, can I reach back out to you? Who's gonna make sure, who I report back to if I've got questions? Obviously, that's you guys.
Mhm.
But what sort of assurances can you give clients in those moments that, I've spent 3 hours with you, I know your full story, you feel like you're
Mhm.
feeling trusted, or I promise that we still got you, even if it's not me on the line.
Yeah, so we take the notes from the attorneys who talk or the volunteers who talk directly with the clients, and we put that in the client file. Kimaya sends out all of our closing letters to clients so that if and when they call us back or have issues 2 days down the road, 3 months down the road, a year and a half down the road, I have gotten calls from clients this week that I represented back in 2019 that they're coming to legal aid. They're not coming out of the blue to you guys. And so that we can get them connected to the help that they need in that moment. And to the extent that their situations develop, that information, those notes from the phone call are documented in our system so that the attorneys who then pick up the case for eviction 2 months later know the background and can see that. The better the notes, the more I like you.
I'll also say that I'm not very good at expunging all of my personal information from any of the files. And so I do get called back from people from all these clinics. And legal aid has always stepped in to help me. Either if I wanted to do it myself, they'll help me with the advice on the follow-up. If I really can't, they'll take the client back and take care of it for me. So don't feel like you're going to get stuck in something you can't get yourself out of.
We also have a quick scenario for what it would look like to come to our courthouse clinic. Yeah.
Cool.
They do have a lease, but what they mean is that their initial fire announcement, but they tell you they don't have a lease, say, really? I have one. And that lease is continuing unless it's been terminated. And if they're there, it probably hasn't been terminated or else they wouldn't be getting sued. So just realize when you ask a question about, do you have a lease? And they say no, you dig a little deep and say, have you ever signed a lease? And if they say, well, I want the last one, right? And then sometimes you want multiple ones if they're debt collection violations, but they'll tell you they don't have a lease when they do.
And at our Lawyer on the Line clinics, Himaya and myself or another staff attorney are always there. You can always ask them to send us documents in the moment that you can then review in the moment.
All right, so the scene here is not Lawyer on the Line. You've come to one of the courthouse clinics that we host on a monthly basis, two mornings a month. And tenants have come out into the hallway, and I'm sitting down as the tenant's lawyer, or as a lawyer attending this clinic.
And I'm Tina Tennant.
To find out what's going on. And as the tenant.
I will say we have these next Monday and Thursday. There will be an email with the sign up tomorrow. Okay, so you're my lawyer, right?
I am not your lawyer right now. I need to get some information from you before we can decide whether legal.
Okay,
aid
here are
is
my
needed.
court papers, and my landlord's trying to evict me because of non-payment of rent, but he's not fixed things for like over 2 weeks, and he increased my rent by $200, and he didn't tell me why or how or anything like that.
And that's all very important, Hannah. But before we can have a conversation about what's going on with your situation, I need to get some information from you to know whether legal aid is qualified to represent you. Legal aid has to do this with all of its clients because of the funding. So, and if you don't qualify for legal aid's assistance, I can provide you with information, but I can't provide you with legal advice here today. So
Okay.
let me get some information. We ask for financial information, and we're assuming that the tenant here qualifies for legal aid representation.
We have paralegals on site who do conflicts checks and help with this intake process in the moment. Let's assume I qualify.
All right, so you qualify for representation. So now let's start talking about your case. Let me find out some information about your case. Do you have the court papers that brought you here today?
Yeah, here are my court papers. They're trying to evict me for non-payment, but I don't think I owe them anything.
Okay, all right. I'm looking at your complaint. This is a box 3 breach of lease case that says that you haven't paid your rent. Why don't you think you owe the rent?
Well, I don't know the rent because there's mold all over my apartment and they're not doing anything. I've been complaining about it since February, and all they do is come in and wipe it down. They painted it over it once, but it keeps coming back. I shouldn't have to pay if there's mold in the unit that they won't actually fix. Plus, the landlord increased my rent by $300 after my lease went month to month in April.
Do you have a copy of your lease with you?
I don't have a lease. It went month to month. I told you that.
So even if it's month to month, that is still a lease. It's just a month to month lease instead of an annual lease. So when a written lease goes month to month, the written contract still governs. It's just on a month to month basis as opposed to being for a longer period of time.
I had no idea.
So it may say
Here's a
something.
copy.
Yeah, it may say something in the lease that's helpful. So let me take a look at it. All right. So it looks like your landlord is allowed to increase the rent as long as they give you 30 days notice before they do so. Did your landlord give you any notice before raising your rent?
Maybe. I honestly don't remember.
Okay, well, that may be something. If they raised your rent without providing you notice, then that could be a debt collection violation, and you may be entitled to get that money back. Plus, there's some civil penalties that could go along with that. But that only happens if the landlord didn't follow the lease's rules, and we're not sure what those rules are when we don't have that, right now. So let me ask you another question about notice. Did you get any type of a notice from your landlord before you got these court papers, the complaint that you handed me earlier?
No, he didn't give me anything. These just showed up on my door one day. Didn't have a sheriff serve me or nothing.
All right. So in your case, it looks like they're only requesting possession. They're not asking for a money judgment against you. So the landlord only has to serve the property. It doesn't have to serve you personally. That's a special rule for these types of cases. But the landlord still has to demand possession of the property before filing the case against you. Do you remember getting anything from the landlord that demanded that you surrender possession of the property?
I didn't get any letters from my landlord. I got this email. It told me to pay, but it didn't say anything about getting out or terminating my lease.
All right. So I'm happy. I'm looking at this. I don't see anything in this email that says anything about demand for surrender of possession. So it looks like you do have a legal defense to the eviction case that brought you here today because the landlord didn't demand possession. So I'm happy to represent you in court today. And unless your landlord has some other document that you haven't shown me, then we should be able to get your case dismissed today. But that's not going to fix the underlying problem, which is that you haven't paid some of the rent that the landlord says that you owed. So you'll want to get caught up on that rent as quickly as you possibly can.
What about those debt collection violations you talked about?
Well, one thing that we could do is ask the court to continue the case, which means just push it out to a later date so that we can investigate that further. But if your landlord didn't give you the notice, then the case might not go anywhere. We can get rid of it here today. So theoretically, we could ask the court to dismiss the case because the landlord didn't give you notice and demand surrender of possession. And you can kind of hold those potential debt collection claims back. And if the landlord comes back after you in the future, if some other issue arises, we could consider whether you should be asserting them then.
Okay, sounds good. What if I lose today, though?
All right, so you lose in court today. Worst case scenario, you have a right to appeal. You can do that within 10 calendar days from today. And you just do that by filing a notice of appeal with the clerk of court. Then as long as you pay your rent going forward to the clerk of court, you can stay in your home until the next hearing, which will be in district court. That's usually about 4 to 6 weeks out. If you don't appeal, or if you appeal but you don't pay the rent bond, that's when the landlord can get a writ of possession and have the sheriff come out and change the locks. I don't think that's going to happen, but even if it does, even if the landlord does get a judgment against you today, don't worry, nobody's coming to change the locks tomorrow. You would still have some time before the landlord would be able to get the sheriff to come out and change the locks. But do you have money to pay your forward rent, the rent that you would owe going forward if we lose?
Yeah, I have that, but I don't have the back rent right now.
Okay, well, that's all right. You may need your back rent eventually, but the rent bond would only require you to pay that forward rent as long as we file what's called an indigency petition, and we can make sure that you have access to that form as well. So if you lose today, I'll walk you through how to file all those forms.
Awesome. Okay, let's go to trial.
Let's go to court.
Awesome attorney. Any takeaways? Any questions? I know we have just gone over our time a little bit.
One thing is when you're doing the financial stuff, I preface it by saying, I got to ask how much money you make. I'm not trying to be nosy, but I need to know to see if I can do it. And then, because you say we have limitations, and then they're going to say, well, how much can I make? You don't ever want to tell them how much they can make, because then they're going to tell you right below it. So you have to say, well, it depends. And this is true. It depends on how many people in your household. So how many people in your household, and then how much money you make. And I got to look at my chart. I don't have the chart memorized, which I don't, because there's a ton of columns. And so just tell them. And then some people, will tell you, and they'll be over, and then you'll say, sorry, I can't do it. You're over. And then, well, actually, I only make this. And, then it's like, oh my gosh, or I just stopped working, or they cut me. That's what I was making. That gets, but bottom line is, don't tell them in advance. Don't show them the numbers. Okay. And then the other thing that I wanted just to come up is, one thing we ought to check every time is ask people if they've been sued before. We win a lot on res judicata. People are suing them all the time. Sometimes money claims, the magistrate, if you win on a notice defense, the magistrate will award them the money because they owe it. But a lot of times they'll just dismiss the money, which I don't really understand why they do it, but I don't argue. And if they dismiss the money and they don't appeal that, then they don't owe that back money anymore. And you can use res judicata if they sue it again, and then you can actually have a debt collection claim because they're claiming they owe money that they haven't. So, ask people if they've been sued before, and it's all on portal now. You can pull it up on your phone, you can search by name, and you can see if they've been evicted before or the case has been filed. And that can be an easy win.
The other thing I'd say is we're not throwing you guys in the fire by yourselves. At every one of these clinics, we have our staff attorneys working side by side with you. If you have questions, you can interview the client. And just like at the Lawyer on the Line clinics, come talk to us, bring one of us in to co-counsel. You don't have to take the cases to trial. You can limit your involvement just to advice only. And if you think somebody has a defense, you can come tap me and I can see if we can find somebody to take it to trial.
There's almost always at least one of the champions there too, sometimes multiple. I love it when there's somebody new who wants to take a shot at representing a client in court, and I can sit right next to them or behind them or something like that and just kind of, provide it. Not that I always get it right, but, it's helpful to have someone who's been through the process, and this is a great environment to try that out.
The only other thing I'd say is please don't forget to get the contact information for clients. You'd be surprised the number of times we walk away with intake sheets without emails and phone numbers to follow up afterwards and send the closing. But it is it's really fun. It gets you on your feet. You get to be a real lawyer in the courthouse for a morning, and it's not scary.
And stuff happens. I mean, the courthouse, it's exciting. There are things going on. I mean, your dinner time conversation is going way up. I'm just telling you, there are, whether it's your case or just watching cases, there is stuff going on. I'm there almost every day. So if you ever just want to go and do a mini clinic with me, come on down. I just wander courtroom to courtroom.
And the need is great. We only do these clinics in Charlotte right now. There are over 30,000 eviction filings that happen every year in Charlotte alone. That's not the rest of the state. So we need you. We can't do this without y'all's assistance. And I have a pipe dream of building a small army of pro bono volunteers. So please join me. Good question. No idea. I can try and look that up though. Oh, legal aid housing 2. So legal aid housing 1, legal aid housing 2. Number 1, all lowercase.
And to make it up for the 5 minutes over, I hope everybody can come to the triage reception at the Grand Bohemian, especially if you registered, but even if you didn't, I don't think they'll turn you away. So come over, there's that upstairs bar at the Grand Bohemian. We'd love to see you starting at 5 o'clock.
Thank you guys.